I'd like to say that.
Welcome back.
So, indeed, it was a great intellectual engagement to understand the legal landscape of Saudi Arabia in the last session. And hopefully, this session will cover up issues again on personal status law, commercial transaction law, penal code, law of evidence, real estate laws, particularly corporate laws, and data privacy laws. These are significant variables to augment the development of Saudi Arabia and towards fulfilling the mission of the Vision 2030 launched under the leadership of Mohammed bin Salman bin Abdulaziz Al Saud. I'm sure the intellectual deliberation that Professor Joseph Kassisian is going to present in this context will be greatly helpful. With these few words, may I request Professor Joseph K. Kassisian to deliver lecture, please. Over to you, sir.
Thank you. In 2022, Mohammed bin Salman gave an interview to the Atlantic magazine, to Grammy Wood, in which he clarified what Riyadh was aiming for was to evolve using the potential of the Saudi people, the culture of Saudi Arabia, and history. He said, "We want to bring something new to the world. Many of our projects are unique. They are Saudi. For example, NEOM, created by our country. This project is developing solutions that no one has provided before." All of these projects, including substantial cultural, scientific, sports, and tourist attractions, all of these require domestic and expatriate labor, but they also required laws. And as I've said, they've introduced 4 written documents now, 3 of which were published, 1 is pending. So I'm going to go straight to the first one. First, civil transactions law, which is the commercial law, really. On June 19, 2023, the Kingdom enacted the Civil Transactions Law. I will just call it now the Civil Code, which was promulgated by Royal Decree M/191 and entered into force at the end of 2023, December 16. Investors looking to be part of the Kingdom's economic growth plan welcomed the newest iterations as the country's legal landscape was significantly clarified, which increased transparency and predictability. It streamlined civil transactions, strengthened protection of ownership rights. By all accounts, this was a major update. It had 721 articles that covered a wide range of topics, from contracts to construction, and applied to both natural and legal persons. The latter was important as legal persons included the state as well as public authorities and institutions. This is Article 17 of the Code. Foreign direct investors welcomed this specific aspect of their contracts with the state or with public authorities and institutions were now clearly delineated because rights, sources of obligations, that is contracts, personal liability, ownership rights, ownership real estate units, if they have any, were no longer left to arbitrary decisions, either by one side or the other. Another fundamental change introduced in this updated code was to build on Sharia, not eliminate it, by relying on judicial precedent that stabilized for business environment instead of relying on various interpretations by judges scattered across the vast land. The law applied in Dhahran, the same law that applied in Riyadh, the same law that applied in Jeddah, the same code that applied in Qasim, the same code that applied in Jizan, the same code that applied in Najran. There was now a uniform code for the whole country. The Civil Code thus offered sorely needed clarity and consistency, even if the binding precedent feature was a work in progress, and frankly, one that would undergo necessary emendations over time. At the heart of the Civil Code was the provision to recognize offer and acceptance, which underscored intent to commit to an agreement. When you want to have a commercial agreement, you have an offer, and then you have an acceptance or a rejection of that agreement. Although contracts did not have to be in writing, since consensual exchange had been practiced on the Arabian Peninsula for ages, an offeree's silence was no longer regarded as acceptance unless the offer pertained to a prior dealing between the contracting parties. In other words, if I were to shake your hand as a deal, we reached a deal now, this was no longer sufficient. It could be, but no longer sufficient. You have to have it in writing. The new code addressed duress, which was a real challenge to consent, as it often exposed the party to danger or that it compelled one of the parties to excessive coercion. Interestingly, the fresh code underlined that compulsion imposed by a third party will no longer invalidate a contract unless the compelled party proves that the other contracting party was or should have been aware of the duress. Even the Sharia concept of ghubn, which is lesion. Ghubn is G-H-U-B-N, ghubn, lesion, which gives the buyer, any buyer, the right to revoke a contract if it is discovered that the price paid was significantly exceeded the market price. In other words, ghubn is when you are cheated, right? You agree on a price and you think that this price is right, but in reality, the seller cheated you by doubling or tripling or quadrupling the price in the market. This is now codified. While a judge would determine ghubn based on customary rules, the introduction of a statutory limitation period, 180 days after the execution of the contract, is an important emendation. I'm not going to give you the article numbers because in the text here, I actually refer to each article and article number. If you're interested in the subject, wait until my colleagues publish the article in Contemporary Review of Middle East Studies, and you can actually have references to the specific articles. Now, this helps large companies with heavy investments because almost always these large companies like to resolve disputes in a very timely fashion. They don't want to wait a year or 2 years or 3 years. Within 180 days, the resolution occurs. After 2023, that's only a year and a half ago, not even a year and a half, almost a year ago, the code further resolved various ambiguities in contracts which upheld various clauses in any given agreement. For example, it discussed compensation in case of a breach and what may be awarded, and settled on jurisdictional matters. As you can imagine, this thorough document provided further clarifications on the ability to claim damages based on negotiations, often a very contentious issue. It addressed bad faith if you're entering into a contract from with bad intentions. It limited anticipated loss of profits, as well as legal and advisory fees spent on negotiations. Now the code specifies what the fees ought to be. How much is it going to be? And there is a range of the fees within which you have to stay. To the delight of investors, the code looked into exceptional circumstances that could hinder the application of contracts, including the mechanism to deal with such circumstances. You have to have notification, negotiations, timely resolutions, all of which required good faith to avoid exorbitant losses on both sides. It also clarified how an agreement was interpreted, the intentions of the parties based on local customs, circumstances, the nature of the transactions, and the honesty and trust that presumably exists between them, all of which removed any and all doubts in fulfilling contractual terms. Finally, the code provided a specific way out to terminate a contract, including arbitration. That is, you don't go to court, you arbitrate. That would avoid expensive litigation that will take time, and so on and so forth. When the Civil Transactions Law was issued, very few people appreciated its pro-business preferences. But here is the genius of Vision 2030. As I have mentioned to you before, pro-business preferences, pro-business preferences. Though many were happily surprised that the precedent-setting regulations ensured that revolving contractual disputes would become far more predictable than at any previous time. Of course, notwithstanding these new regulations, it remains to be determined whether Saudi courts would confirm whatever entitlements were presented to them for resolutions. Although painstaking negotiations during the writing and vetting period the code was issued, and that involved members of the judicial establishment, obviously everybody had good intentions. It's still, I think, wrong to assume that the civil code replaces Sharia, which is not the case. I want to repeat this time and time and time again. But it advanced a modernization of the Saudi legal system, in this case in commercial areas. For example, Article 385 of the new code. As you can imagine, I read all 720 plus of the law. I had to read it, and I'm not a lawyer. But Article 385 of the new code bans any kind of interest in leading transactions. Do I need to remind you that this is in full compliance with Sharia? It is in full compliance with Sharia. Article 385 says no interest. Well, Sharia says no interest. So it's the same thing. So therefore, it is compatible with Sharia. But now, what it does, it prohibits lending transactions to avoid cheating. Now, it remains to be determined how the courts plan to limit the principle of prohibiting interest that once again underscored that these reforms were work in progress that required precedents adjudicated by magistrates over a period of time. Indeed, as there were hundreds of articles in the document, which experts were expected to work through the proper legal settings, both to protect the business entities that engage them to complete contractual agreements and otherwise conduct equitable business relationships in the increasingly transparent economic environment that ensured legal protection. It was natural that the process would be a long time process. It will take time. Still, there were limitations in how fast these measures would be applied, as the civil code did not deal with conflicts of law, which was not unusual. A Saudi court would always apply Saudi law first and foremost, and would not recognize a choice of law clauses in an international agreement. Saudi law comes first, international law comes second. This is similar to legal injunctions in most countries that confront business and corporation dealings with such challenges. Italian law is the first law in Italy before international law. Indian law is the first law that applies before international law. Still, Riyadh introduced two important exceptions to the sacrosanct aspect of the law. First, as the kingdom acceded to the United Nations Convention on Contracts for the International Sale of Goods, this is called CISG. Sometimes it is known as the Vienna Code because it was signed in Vienna, or the Vienna Convention, if you like. CISG, United Nations Convention on Contracts for the International Sale of Goods. So Riyadh accepted this, was committed to upholding CISG regulations in all international sales, unless the parties agreed otherwise. If there is agreement between you two of you, you don't have to apply it. But if you don't have an agreement, this law applies now, starting in 2024. Second, the existing Saudi arbitration law, which had come into effect in 2012, that is before these reforms were introduced under King Abdullah, and that permitted parties to determine the law applicable to any dispute, meant that disputes could be adjudicated according to the proper law of the contract, provided that the agreement contained an arbitration clause as discussed above. Again, these two exceptions illustrate what the element of transparency in conducting business with and in Saudi Arabia, and this must be reiterated, is further evidence of the country's commitments to fulfilling international obligations without, I repeat, without breaching Sharia. All of these laws without breaching Sharia law. What this further signaled was that after December 2023, when this code came into effect, companies looking to invest in Saudi Arabia were reassured to buy, perhaps for the first time, minority stakes in up-and-coming entities as Riyadh sought to woo new capital to wean the economy of fossil fuels. Remember what I told you about Vision 2030, to replace reliance on petroleum resources, to have a productive economy, not to have a single product economy, which is oil. According to a Reuters report in 2022, the kingdom secured less than $40 billion in foreign direct investments, though its target now was to reach $100 billion by 2030. 40 billion was no longer considered to be sufficient. What Mohammed bin Salman's Vision 2030 aims for is to get a significant foreign direct investment to come in. And this transaction law, the code that we're talking about, is precisely engineered to encourage FDI at the tune of $100 billion per year. Now there is legal clarity readily available. Banks, law firms, asset managers, corporations that are establishing offices or weighing investments in the Gulf's biggest economy are confident that they can do business in the kingdom. For a leading Saudi attorney who managed a law firm and who was trained in both Saudi Arabia and the United States, this new transactions law was a quantum leap in the nation's legal system. For another practitioner, I won't bother you with the name, the new legislation marked a milestone as the first codification of civil law in the kingdom. And while the legislation continued to apply Sharia, he foresaw how previous court interpretations of Sharia-based guidelines and principles would enhance the judicial system's consistency and predictability. Now, before I go, this is as far as I'm going to say about the transactions law. But before I go to the personal status law, I forgot to mention something in the first hour, which I just remembered. I'm an old man. I remember things. And I forget things. Now, in the past decade, approximately 30,000 legal cases were documented and published. 30,000 precedents. That's unheard of. Now, there is a library in a law office, in all law offices. There is a library behind attorneys' desks with multi-volume codes, precedents. So if a judge now confronts a dilemma, does not know what the precedent says, can go to that particular document, pull it out, and see what previous judgment has been passed on the subject, and say, we're going to apply this precedent. This is unheard of. This is new. This is important for businesses. Businesses like stability. They want to know exactly what they're getting into. Businesses don't like surprises. There are no surprises in business. I need to know what the rule is. I will follow the rule or I will not follow the rule, but I need to know what it is that you want. And you tell me what you want. Be clear. Don't confuse me. Tell me what the rules are and I will follow them. So now there is precedent. As I've said, 30,000 cases have now been published, and every year more and more are being published. In the book that I co-edited with Sarah Al-Muhammadi, I actually devoted a chapter on this, which I'm not going to bother you with now, in which I talk about all this precedent, and Professor Kumaraswamy read the book and he knows about it. This is something totally new, and nobody expected this to happen. Now, it doesn't mean that all the lawyers have read all 30,000 codes. It will take them a while to figure this out. But on a case-by-case basis, and over the period of years, more codes will be added, of course, but attorneys will be specialized in certain fields, and they will focus on the particular precedents in their respective fields. Okay, let's go now to the second, personal status law, which is the family law issue. In 2022, in March 2022, the Council of Ministers of Saudi Arabia passed the new personal status law, which came into effect a year later, June 23. Again, let's look at what the critics of the new law said. Again, I remind you, this was not codified before. They believed, that while it did address genuine grievances, nevertheless, it enabled discrimination against women through male guardianship provisos. As I've explained to you earlier, male guardianship has a priority for children that are before 7 years old. Male guardianship has a great deal of power in a marriage over women. Male guardianship, the mahram idea, is very powerful. It had all these rules about how women could behave in society, even when you have to have emergency surgery, for example, for a variety of diseases, you have to have the mahram present and give the approval. So in the past, it was very discriminatory. The chief reproach, for example, made by Amnesty International was that only men could be legal guardians and that women must have a male guardian's permission to marry and were then obligated to obey their husbands. Amnesty International concluded that the law did not give women and men equal rights over matters relating to their children in the event of separation or divorce, and while the denigration acknowledged that a mother is automatically granted custody, which is what the new law says, the father is designated as the child's legal guardian without due consideration of what the best interest of the child might be. Saudi women praised the new personal status law, since the overwhelming majority believed that it would help families to reach more stable levels. As you will see in 1 second, the law empowered women and promoted civil rights, though changes were evolutionary rather than revolutionary. For example, the new measures identified many more employment opportunities and solidified women's standing in the legal system, which were non-negotiable. For the first time, Saudi women were free to run family affairs with full independence, as various core concerns like alimony, child custody rights, various protective measures for those who filed for divorce were now clarified. Instead of leaving vital judgments like the obligations that men have to provide housing and sustenance to judicial interpretations, the new law specifies what those are. Women confronted with divorce and who naturally struggled emotionally as well as financially were now on an equal footing with men who, and this is important to underline, could no longer evade their responsibilities. Men, under this new code, are held accountable. If the absence of a clear legal framework in the past was painful for many individuals and families, especially women, it permitted some to evade their responsibilities. Now, that is not possible. Not only you have specific Sharia obligations, but you also have legal obligations if you're a man. You can't just say sayonara, as they say in Japanese, bye-bye, I'm leaving. No, you have obligations now. You have to pay alimony now. You have to assume responsibility now. Now, what are the more positive developments introduced in the new personal law? In addition to promoting women's rights in general, women were no longer legally required to ask for permission to travel. They're no longer required permission to marry. They can make personal choices. A marriage is no longer a family decision as a bride-to-be could refuse. She can go to court and do whatever she determines to be in her best interests. No more arranged marriages against her will. Perhaps the most important codification was to ban underage marriage for girls less than 13 years old. Now imagine, we're talking about a paternalistic society. Don't forget that tolerated in the past underage marriages for centuries. Of course, not just Saudi Arabia, a lot of countries did that, including India. The bride-to-be could no longer be married off against her will. Although teenagers continued to have the right to marry a person of their choice without any interference. The subtlety was an important step that should not be overlooked, as the law confronted imbued traditions that were centuries old. Under the new personal status law, women could also file lawsuits, review their marriage contracts, and weakening clerical authority to an unprecedented level, codify that no cleric, no clergyman can marry a woman without her verbal acquiescence, without her consent. In the past, judges did not even bother to ask a woman whether she wanted to marry or not, whether she was underage or overaged. They could just write it off. The new code forbids that. A judge cannot marry a woman without her permission, without her saying yes. In other words, what the new law advanced went beyond divorced women earning the right to become legal guardians of their children, beyond alimony rights, beyond securing child care support. They were able now to acquire legal privileges that existed under Sharia law, but they were not applied in the past. Sharia provided those laws, but urf, traditions, prevailed over what the religious precepts were. Now it's codified. Now there are legal protections. Now let me look at the third penal code for discretionary sentences. As I've told you about the different sentences. The penal law in Saudi Arabia, which is fully governed by Sharia, promoted deterrence as well as retribution. It was characterized by certainty and contained an element of finality in its rulings. Again, save for a royal pardon. The king can always pardon anyone he wants. Finally, it included a clause for speed in the execution of its decisions. This was the reason why crime rates were relatively low in the kingdom, as personal violence was extremely limited and core rights to property rights were fully protected. There were no doubts that the firm and deterrent effects of Sharia criminal law, the influence of Quranic teachings, a carefully tailored education system, and age-old traditions that grew succor from tribal behavior that was based on honor and respect were responsible for this record. In fact, crime is very small in Saudi Arabia compared to other societies. There is crime, but it's tiny compared to elsewhere. Decriers found several objections to the new code. Now, with 414 articles, up from the 2001 version that only had 225 articles in it. Though this is not a very important point. After February 2021, Riyadh announced that the country's first written penal code for discretionary crimes, crimes whose punishments were not specified in Sharia. Remember what I told you about hudud that are specifically cited in the Quran versus ta'zir, the discretionary judgments that sheikhs and imams and mullahs in Iran pass. Although the final draft of the penal code is not published as of this writing, because, as I've told you, because of the controversy over the death penalty, a draft that included 414 articles was circulated that classified crimes according to their prescribed punishments as felonies and misdemeanors. Existing laws, including the counterterrorism law as well as the anti-cybercrime law, carried very vague language and blatantly broad provisions that, not surprisingly, were widely interpreted and abused by judges who believed that Sharia allowed them to prove that a defendant engaged in a certain act, which was then classified as a crime. The latest efforts listed old regulatory crimes, which were previously classified under specific penal provisions: cybercrime, terrorism, harassment. The new penal code listed novel crimes that no earlier iterations of the law had even thought of. Critics overlooked that the judiciary of the kingdom, perhaps for the first time, confronted serious legal challenges like racism, discrimination, hate speech, all of which were now punishable by law. Equally important, the law further specified that non-codified crimes would no longer be punishable by judges. A qadi, a judge, a qadi, Q-A-D-I, they don't have the discretionary power to pass judgment. They don't have that discretionary power anymore. The qadi, the judge, must follow the code now. There's no more the right to do whatever you want. This has taken away significant privilege from the judiciary. The judges are not free to do whatever they want. They must follow the code. This meant, in effect, that Saudi legal reforms now distinguish between religious cheekiness and criminality per se, which henceforth would be judged according to clear and specific sentencing rules. For this crime, this is the sentence: 3 months, 6 months in jail, 8 months in jail. You cannot say, I judge you for 3 years in jail. You don't have that right. If it's 6 months, you as the judge must apply the code, 6 months. You cannot say, I don't like this person's face. I want to send them to prison for 6 years instead of 6 months. You don't have that right anymore. Whatever critics claim, in my view, this was a major transformation, as existing overlaps, perhaps even the very concept of interchangeability between sins and crimes, were no longer accepted. Henceforth, specific crimes were judged to far more specific criteria and in turn carried specific punishments. One of the non-codified crimes, for example, is istihab, 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 which is the illegal companionship of the opposite sex. If a couple that are not related, that are not married, are in each other's company, this is istihab, which meant that mixing or ikhtilat, mixing between men and women, presumably, or between men and men, or women and women, in public places. Now, some clerics interpreted this as being potentially harmful, presumably because it could lead to decay and debauchery in society. Guess what? This is no longer a crime. If people want to mix, they want to be together, this is not a crime. Likewise, the new penal code did not mention group prayers or even the closing of commercial shops during prayer time. As you know, in Islam, you pray 5 times per day. If you want, you can collect the prayers and include all prayers in one session or 2 sessions, depending on what you're doing. You don't have to follow. The new code does not mention group prayer, that you have to all pray together, which is what people do on Friday when they go to the mosque. But during the week, they don't all rush every 5 minutes to the mosque to pray in group. You can pray by yourself. You can pray alone. In earlier iterations, failure to attend group prayers was a punishable offense, as well as commercial activities during prayer times. If the shop was open while the prayer was called and you were doing business, that was punishable in the old days. Not anymore. The new code further banned lashing as a discretionary punishment, as it recommended alternative penalties like imprisonment and fines that again interfered in established judicial practices that allowed judges to freely adjudicate sentences. Equally important, corporal punishment, as practiced before the promulgation of the law, was now literally abolished. To be sure, the death penalty is not eliminated, as I've said before we took the break. But it was retained for very specific crimes, such as murder and intrafamilial rape. It's those things. Intrafamilial rape is still considered a punishable offense. Saudi courts that routinely sentence people to flogging for ta'zir, I remind you what ta'zir is, discretionary punishment, right? Always remember that. Ta'zir, T-A-I-Z-I-R, discretionary crimes, for example, for sex outside of marriage or drinking alcohol and similar offenses. In the past, you were flogged for that. We're now called upon to follow specific codes that introduced uniform punishment. For example, if somebody was caught drinking alcohol in Jeddah, the judge, discretionary judgment, used to say, flog him 3 times. Whereas in Qasim, the judge will say, flog him 62 times. He wants 62. Why he wants 62? He wants 62. He's free. He's a judge. Not anymore. Gone are those arbitrary arrests that did not even inform suspects of the crime with which they were charged. Under the new penal code, lawyers are allowed to assist suspects during interrogation. They're allowed to examine witnesses and present evidence in trial. Gone are the arbitrary judgments that routinely convicted and sentenced defendants, often on allegedly forced confessions obtained under duress, which was certainly a step in the right direction. It may be accurate to state that the new code left untouched the substance of Sharia criminal law, as Sharia rules that applied to hudud. Hudud, as I told you, are the punishments that are specified in the Quran for the big crimes. Remain, those are the way they are. They are intact. They have not been codified. They're still the same punishment, whichever is in the Quran is still there. Therefore, when the putative crimes become ta'zir crimes, legislating the latter became a power now resolved or reserved solely to the state, which adopted the principle of legality that effectively meant that only the law could define crimes and prescribe penalties. In effect, the code restricted the roles of the judges to adjudicate criminal cases, inciting them to strictly apply the new penal code. Now, before I move on, this has not been published yet. This is the one that's still pending. So it's work in progress. But mark my words, it will be published, like the other three. This one will be published as well. Now, what are the new chapters in Saudi legal reforms? I'm going to skip over some of this because it's too long and we don't have time. We don't have time, and I want to open for conversation. So I will skip this part. You will read it in the paper when it comes out soon, hopefully by June or July. Okay. So now a new direction of legal reforms is underway, as you know. One might take several years to mature, but that inevitably will result in clearer codes in the books. Civil, criminal, economic concerns have evolved in the 4 new codifications, introduced significant new changes, and in most instances clarified, even simplified the law. They helped streamline courts and tribunals' powers relating to contempt matters and the kinds of appropriate penalties the latter imposed. It's worth repeating that the latest codes did so without reneging Sharia, the kingdom's core legal precepts, which will always remain its legitimizing stake. So please don't ask me whether women are discriminated against. They are not. Now they are protected. Don't ask me whether the judges can do whatever it is that they please to do as they have done in the past. They cannot anymore. Those days are gone. Now there is a code to follow. You don't like it? Look for another business. Do something else. And the state now is making the law. This is perhaps, I will stop here for 1 second. This is perhaps one of the key things of Vision 2030. You know, it's a subtle, Vision 2030 talks about economy, right? We talked about that yesterday. But there is a lot more to it. And I repeat it. I said it now 4 times. This is the 5th time I'm saying it. It empowers the state. It gives the state hold of the law. The state now becomes a legal entity. And that's powerful. You cannot just dismiss. The state now has power. That's its concrete example of what it means to be powerful. Now, consequently, it may be appropriate to state that Riyadh ushered in updated versions of its existing laws that favored transparency and accountability to add value instead of uprooting a pillar. These steps fulfilled Saudi traditional preferences, although few outsiders, especially those who are unfamiliar with its society or who are very impatient with the pace of its reforms, fail to note that epochal changes are underway. As we discussed, important civil law reforms were ushered after 2022, led by the first personal status law that intended to regulate private law relationships in equitable and transparent ways. The law of evidence, which also came into effect in July 2022. What is the law of evidence? You eliminate discrepancies in courts. What is the law of evidence? Think about it. No more freebies. That's the law of evidence. There is no more discrepancy. Every judge cannot behave as if he is the law himself. No. The law of evidence is that the same rules apply across the country for everyone. That's the law of evidence. You present the case, the evidence says this, the code specifies the punishment, you apply the law, you apply the punishment. It's either financial or, in egregious cases, it is you go to jail or in prison or whatever. Now, the law of evidence, as I said, eliminated discrepancies in courts, while the new penal code of discretionary sanctions, this is the first time, I remind you, this is the first time in the history of Saudi Arabia where you have a written penal code to cover crimes for which there is no Sharia specified punishment. This is the first time. Sharia has specific code, specific punishment for specific crimes, but not for everything. So therefore, you have a written code for the first time for non-Sharia compliant crimes. Now, you have to be patient to see when this will be applied. And while the super sensitive personal status law reinforced aspects of the male guardianship system, it did not totally dismantle it. The male guardianship system is still there. The mahram is still very powerful. But that has now changed as well. I think it will be a travesty of justice to ignore the critical steps that have been taken to improve conditions, strengthen family life, protect women. Critics are demanding a formal constitution and several fundamental laws. This is facile to list and ignores the existing of a text that drew inspiration from the Holy Scriptures, though authorities, both secular as well as religious, recognized that reforms in the 21st century were necessary to end confusion, strengthen basic rights, and gradually introduce independence for the judiciary. Therefore, it's fair to state that the goal of these reforms was to reevaluate how major additions have left their impacts on Saudi society that, in turn, strengthened the country's evolutionary efforts to meet various human rights goals. In the first hour of our discussion, you remember I quoted Mrs. L08, the president of the Saudi Human Rights Commission, where she spoke in Geneva defending Saudi changes. The kingdom, she said, was committed to meet the highest global standards in promoting and protecting human rights as part of its Vision 2030 projects. She emphasized that Riyadh attached great importance to the Universal Periodic Review, the UPR, of the UN Human Rights Council and took the UPR mechanism seriously. For those of you who don't know, the United Nations has this program called the UPR, United Nations Periodic Review. They do it for all the countries around the world. They do it for India as well. Well, but they go back around from one country to the other and look at the human rights record of the country, the laws of the country, the punishments, and so on and so forth. So they did one for Saudi Arabia as well. In early 2024, Tuwaijri reiterated that Saudi Arabia had supported and implemented the majority of the recommendations presented during the previous 3 review cycles, with the kingdom implementing 85% of the 450 specifically identified improvements. That's not bad. 85% is pretty good. If you have 450 recommendations and I apply 85% of them and you're happy with the results, that's good. That's good record. Amazingly, most of these reforms were implemented at the legislative, judicial, executive, and procedural levels as the country adopted new legal and institutional frameworks for promoting and protecting human rights. Irrespective of any unfulfilled conditions, and I'm sure there are quite a few, Riyadh's systematic commitments to adopt and apply fair, clear, transparent laws illustrated that King Salman, excuse me, and heir apparent Mohammed bin Salman were both determined to fulfill their pledges to transform the kingdom so that the country could find its rightful place among the nations of the world. It's work in progress, but oh boy, it's good stuff. It's good reforms. I'm happy with it. I'll stop.
Thank you, Professor Joseph Ekesician, for your insightful views on civil transaction laws, commercial laws, personal status law, penal code, and finally, the law of evidence. Moreover, these laws, in my perspective, are to be inclusive, competitive, transparent, and compliant with the global standards to steer the trajectory of development in Saudi Arabia in particular. And as he has just mentioned, that Saudi Arabia can find a meaningful right place in the Committee of Nations in the future. Thank you. So the House is open for discussion. The first round commences now. इसको पूरा लेना है.
Take the whole thing. Take the whole thing.
Take the whole.
It's heavy.
It's
he says.
easier rather than try to put it back in.
He says it's heavy.
No, it's okay.
You remove it.
Yeah.
All habits are hard to break.
It's a complex category.
It's complex.
Thanks. Like individuals, societies do not like to change. They're very comfortable with all the things. So you identified the 30,000 all the past codification of the previous verdicts. But I've seen it because in the book you mentioned what are the circumstances. For the larger audience, I have two questions which are probably related. Because people do not change voluntarily, what compelled the rulers and the king to bring about such a codification in a detailed form? What's a compelling factor? That's number one. The related to that, since people do not like changes, because the discretion is a great thing for human being. Because I can give a 3 lashes, I can even forgive him. I have both options. That's at my discretion. People enjoy discretion. So therefore, if you are going to put them into a legal framework, this is how a judicial verdict had to be, it takes away the freedom of a vast number of people. So what kind of resistance or opposition you can identify in codifying these laws? I'm only talking domestic. Both. Thanks.
Very short. Thank you, Professor. A related question. As Professor Kumaraswamy was saying, that change is difficult to introduce and adapt. While it is good to have all the laws codified and everything, how is it in terms of practice? Are people ready to adopt these changes?
Thank you, Professor. I have two questions. Two questions. I would like to know.
How come all of you have 2 questions and not just one? You want to confuse me more than I'm already confused.
Very brief, very brief. First, I would like to know more about the citizenship laws in Saudi Arabia, particularly referring to the Saudi women marrying a foreigner. Does their children are entitled to Saudi citizenship? So that is first I want to know. Second is, in some of the GCC countries, there is something called family book, which is, in UAE it's there, I think it's there in Saudi Arabia as well, which is more than a citizenship, I mean a passport. These family books are makes them entitled to the social legal benefits. I think it's there in Saudi Arabia also. If then, could you elaborate on that? Thank you.
Let me answer these and what compels rulers to introduce reforms? Why are rulers so anxious to introduce reforms? You know what? It's because they don't have a choice. They either reform or they die, or they sink. As I've tried to explain, the alternative in societies, if you don't manage proper societies, you have revolutions on your hand. You have upheavals on your hand. So the foresightful leader is the one that anticipates potential problems and deals with them before the whole place blows up. Now, what we have seen in the Arab Spring also occurred in Saudi Arabia, and people were assuming that the king of Saudi Arabia would follow the footsteps of the Tunisian president and the Egyptian president and the Yemeni president and so on and so forth. But it did not happen in Saudi Arabia. In fact, there was a day of rage expected to occur on 11 February, that is just a few days after the Cairo developments, but nothing happened. I was in Saudi Arabia that particular week, and I looked around for the day of rage. There was a day, but there was no rage that day. Nobody showed up. Why? Because people understood that if we want reforms, if we want change, it has to be done gradually, properly, slowly, in an evolutionary fashion. Otherwise, we'll have bloodshed on our hands, like what happened elsewhere. We have seen what happened elsewhere. Earlier, when we were talking with the PhD candidates on the seminar, we were talking about the Al-Nahda movement in Tunisia and the revolution that occurred there. Well, that was a pretty bloody affair. Lots of people got killed. Nobody got killed in Saudi Arabia. Why? Because the rulers anticipated, and they decided they better make sure that they address these issues. King Abdullah, when the Arab Spring started, was in Morocco, in his Moroccan home. He immediately came back home and addressed the issue and spoke to people, spent a lot of money, provided all these incentives for people, anticipated problems. Sometimes they don't have a choice. Now, in terms of the take on the freedoms of judges and so on and so forth, a lot of people have obviously lost their power. Judges now are no longer free to adjudicate the way they flimsy way. No, those days are gone. Now you have to follow the rule. There is a code. There is a uniform law of evidence. You have to present it. The code is specific. There is precedent. Now, for those of you, I mean, in India, it's like most westernized societies, or modernized societies, I should say. In India, you have precedent in law. If something happened 5 years ago in Chennai, okay, that becomes a precedent, and the law is applied in Mumbai 5 years from now. It's the same thing. Well, this is new for Saudi Arabia. Of course, the judges are going to lose their power, and they've lost their power. Alhamdulillah. You know, I'm glad that they've lost their power because they were not fair. And now they're obligated to be fair. People deserve fairness. They don't need arbitrary decisions. Just because I like it, I want to rule my way. I mean, I'm exaggerating, of course, but in order to make a point. And the point is, now you have to follow the rules. And you lose the power in the process? Yes, you do. You lose the power in the process. In practice, how are people reacting to it? You know what? People are very happy. It's clear now. They know where they stand. And especially women in Saudi Arabia, they're very happy with these new codes because now they know where they stand. Now they know how the law protects them. And they don't have to arbitrarily submit. So they are very happy. The majority of people are very happy. The business people are even happier because there are no more discretionary rules out there. Everything is being clarified. And as I've said in my remarks, the business people, they like stability. They don't like instability. And somebody mentioned about the family books and so on and so forth. Marriage with foreigners and the rights that foreigners have. It complicates matters, but the new code specifies specifically what the rules are for Saudis, both men and women, married to foreign subjects. And the family books actually are evolving as well. In fact, during the break, one of you was asking me about orphans in Saudi Arabia. In fact, it was you, yeah. There are no orphans in Saudi Arabia. No orphans. Because when a person dies, the children are not abandoned. The family takes those children in. If the husband dies, the dead person's brother, senior brother, takes his sister-in-law and the children of his deceased brother's family, he takes them as his own. He doesn't adopt them. They don't become adopted kids. They become his own kids. There is no adoption. They're part of the family. And the family book provides all of the privileges for the children of that kind of a situation. The family book actually is a mechanism to provide privileges and so on and so forth, welfare programs and things like that. So it's a very beneficial thing, and it's evolving, and the code addresses them. The code has, there are 700 plus articles in this code. So everything is covered. Trust me, they left nothing to the imagination. All right.
Second round now, please.
Thank you, sir, for your lecture. So my question was related to the clergy. So where does the ulema figure in these legal reforms? Do we see that their power has decreased than before? Will there be any kind of reforms within the ulema as well?
Good evening, sir. Thank you for your lecture. Sir, I would like to know if Saudi Arabia recognizes the people of the book, and does it have different personal status laws for the people of the book, or is it the Sharia law which prevails?
Hello, sir. As you mentioned about the guardianship law, it has been changed but not dismantled completely. You also mentioned that marriage is not family affairs, but it's an individual choice, as any individual or clerics cannot marry a woman without her consent. So, so I forget actually it's second question.
It's okay. But
Yes, sir.
I missed your question. What is your question?
It's guardianship law, sir.
Guardianship laws. Yeah.
Yes, sir. The male guardianship law actually, which
Yeah, what's your question though, about it?
actually I forget the question,
It
sir.
was not completely dismantled. So
Yes.
what are you asking me about it?
Actually, I forget, sir. The second question reminds. Yes. The second question, sir, can a sin which is mentioned under the Sharia law will be criminalized, are criminal crime in Saudi Arabia or vice versa? Are all the crimes is mentioned under Sharia law? How kingdom deals with this?
All the crimes. Yeah, okay.
Or all the sins are under Sharia law?
So my question is a bit basic one. So what is the procedure for codification of non-Sharia law, and how it is different from a democratic setup like us, where we have a dedicated organ, parliament, which is doing it, and it's a complex exercise. So is it a royal farman which is doing it there?
All right. Let me answer these first. Now, tomorrow, the last day of this course, is devoted to studying the religious establishment, the ulama. And I will say a lot more about the ulama tomorrow. But where they stand, they were at the top of the totem pole. And there was an alliance. You're anticipating my lecture tomorrow, but I will very briefly summarize it for you, where you had a pact between the Al Saud and the Al Sheikh, which is the ulama, essentially the religious establishment, and the ruling family of the Al Saud. And there was co-equality at that level. Guess what? Things are changing. The state primacy now is higher. The ulama are still important. They still play critical roles, but not as they used to in the past. So they better get used to the new way of life. Have all of them got used to it? No. Will some of them will have difficulty accepting the new system? Yes, they will have difficulty. But anticipate more of this tomorrow. Okay, be patient 24 more hours, less than 24 hours. Now, you asked me about the people of the book. Muslims, whether they are in Saudi Arabia or anywhere else, accept the people of the book. Both Christians and before Christians, Jews. From a religious point of view, from a dogmatic point of view, there is acceptance. Islam is the third monotheistic religion, and Islam completes monotheism. Judaism first, Christianity second, Islam third. And in Islam, if you have not read the Quran, which I recommend that you do, there is an entire chapter on the Virgin Mary. The Virgin Mary is very highly praised. Even Jesus Christ, which Christians consider to be God, is a prophet in Islam. And of course, in Judaism, Moses and all the other prophets are all in the book. And Islam, with the Prophet Muhammad, is supposed to complete this trilogy of monotheism. It completes, it closes the circle. This is what Islam is all about. Now, this is at the theological level, at the religious level. It's not at the political level. The difficulty that Islam has, for example, with Christianity, and I have to be careful here, is that Muslims think that Christians believe in the Trinity, right? The Father, the Son, and the Holy Ghost. Muslims believe that there are three gods here. There are not three gods in Christianity. There is only one God. The one God has a Trinity. And it's, even for Christians, this is very confusing, of course. The Father, the Son, and the Holy Ghost. The Father, the Son, I can understand. Holy Spirit is a difficult process to absorb, even for a Christian. But Muslims reject the Holy Trinity. They say you can only have one God, and you should only worship a single God. If you worship more than one God, Muslims will say this is shirk, and it's not acceptable. But in Christianity, there are no three gods. The Trinity does not mean there are three different people. Again, as I said, this is a hard concept even for Christians to understand. And even Christian priests have difficulty with this, especially, as I said, the Holy Ghost, the Holy Spirit. So on that level, there is a difference. The people of the book are accepted, but certain provisions of the Holy Book in Judaism and in Christianity are not accepted for Muslims. But Jesus Christ is called Isa in Arabic and in Islam. Isa is Sayyidina Isa, they say. our Lord, the Prophet. He's a prophet. At the political level, it's entirely different. At the political level, Judaism and Christianity has taken on political dimensions as well. And of course, in some Muslim countries, there is difficulty accepting this. But you know what? Saudi Arabia was developed largely by Christians in the contemporary period. Oil was discovered by Christians. It was not discovered by Muslims. And Abdul Aziz, the founder of the kingdom, Abdul Aziz bin Abdul Rahman, was smart enough to know that he needed these Westerners, these Christian Westerners, because they helped them. First of all, they were not looking for oil, they were looking for water. It was a bonus that they discovered oil in the process as well. It was mostly Australian and American foragers that discovered all these things. And now, of course, in the kingdom, you have a huge expatriate population, not just monotheistic, not just Jews and Christians, but you have Buddhists, you have Shintos, you have people from all over the world. And whether or not, somebody asked me whether or not there will be churches one day in Saudi Arabia. There could be, just like there are in Abu Dhabi, in Dubai, in Qatar. We'll have to wait and see whether that will reach that point. There aren't right now, but there could be down the line. In terms of the crimes, in terms of what is written down, yes, the codification now specifies crimes that were not existing before. For example, racism. Racism now is an identified crime. If you have a racist comment, if you go in public and say, I apologize for using that term, but I need to illustrate it. If you call a black person a nigger, you go to jail. So there are specific crimes now that have been specifically identified, and it's being codified. Racism is the most prominent one, and there are a whole bunch of others as well. Look, as I've said, you know, all of you are anticipating. It's natural to have these questions, but you have to also be patient. You have to be very patient. Legal reforms take an eternity. Think, earlier I was talking about habeas corpus when I talked about the UK, or I was talking about France, the Declaration of the Human Rights, right? In the first hour of this discussion, we were talking about this. Or even when we were talking about the United States Constitution, we were talking about these things. Do you think that these things happen in 10 years? I got news for you. I got news for you. It took hundreds of years to get to this point. Hundreds of years. All of a sudden, Saudi Arabia must accomplish all the reforms that one can imagine in less than 10 years. Why are you taking so much time? Get on with it. You know, there is that attitude. I don't know why. I don't understand this. Why are being so, all the critics, I love critics, because it's so easy to criticize. It's so easy to criticize. All the critics are impatient. Saudis are this, Saudis are that, Emiratis are stupid, Qataris are idiots, you know, human rights violations, left, right. روقوا يا جماعة, روقوا, طولوا بالكم شوي. Be calm, calm down, things will happen. It will just take time. Don't think that all of these reforms occur within a matter of 10 years, 15 years. Thank God that they started with the reforms, and hopefully they will stay on the right track, and over a period of time, a lot of members of society will benefit from the changes that are being introduced. There will always be losers. In life, there are two kinds of people, the winners and the losers. Right? Is there a third kind that I don't know about? Tell me. There are always winners and losers. Those who had power lose it, or they keep it. And those who did not have power take it, and they become the winners. This is human nature.
Next round.
Thank you for the comprehensive insights. Sir, I wanted to know that do you see any possibility for the commodification of religion to the level of what we see in country like UAE?
Like the UAE?
Yeah.
Okay.
So what
The same kind of codification? Is that your question?
commodification, sir? Commodification of religion. Like
What does that mean? Modification in what?
sir, commodification, using religion as a sort of commodity for economic purposes.
Religion as a commodity. As a commodity. As a transactional commodity.
Yes.
Religious reforms and religion becomes a product which you sell.
Okay.
Gain.
Leverage, some sort of a
Will the
leverage.
Saudis be able to sell this to the Emiratis?
Will it be a product that they will
Will
sell?
be a product? No, don't go there, don't go there, please. Don't go there. I mean, this is, don't go there. This is, we don't want to get involved in this kind of conversation, no. That's too pedantic.
Sir, as the new law is coming into force in the Saudi Arabia, so sir, do you think that judiciary is facing any kind of challenges in terms of manpower, in terms of educational, institutional development, or the technological, technological advancement in the judicial system in Saudi Arabia? Thank you.
That's a good question.
Good evening, sir. My question is, Saudi Arabia bans unmarried couples living together. It is applicable to both civilians and foreign nationals. My question is related to football superstar Cristiano Ronaldo, who is playing in Al Nassr with his girlfriend Georgina and 5 kids is there. Is Saudi Arabia giving a special permission for Ronaldo, or is it a way with which eminent professionals can be attracted to Saudi Arabia? Clearly, there has been a permission given to Cristiano Ronaldo in this regard.
How can I answer that question? I'm not going to answer that question. Next. He's embarrassing me. Who else? Okay, I will answer the manpower and judiciary.
Just apply.
See, what you said about the reforms, it's hundreds and it's a centuries of process. There is one small thing, it is an ongoing process.
Yes.
Democracy and reforms don't end in, okay, I've done and dusted. No, you keep on improving on a daily basis, both an individual, society, and the state. So it's not that, no, I've done, finished, my job done. So it's an ongoing one.
Of course. But the question about the manpower and the judiciary is very important. Look, there are, in Saudi Arabia, there are approximately 30,000 mosques, right? And each mosque has a imam or a sheikh or a preacher. And there are, unfortunately, too many members of the religious establishment. Therefore, the manpower is fairly large. And you have to divide this manpower into 2 parts. I am being honest now. I'm being critical, but I'm being honest. There are the competent religious clerics, and there are the incompetent ones that have become religious clerics for a variety of reasons. Some people may have had the calling. I don't say no to that. They are inclined to pursue a religious vocation because they are the calling. But other people, they've become clerics because they could not find any other job to do. I'm sorry to be so blunt. I'm very sorry about that. But this is not just true in Islam, it's true in all religions. It's true in Christianity, it's true in Judaism. Just because somebody becomes a priest doesn't mean that he has the qualifications or the vocation to become one. But because he could not do anything else in life, he's a total failure, so he figured out I'll become a priest. You know, it also exists in other religions as well. Manpower, but what we are interested in for our purposes, because we're talking about legal reforms, and in Sharia compliant society like Saudi Arabia, all of the laws are vetted according to Sharia. As I have repeated time and time again, that nothing contradicts Sharia. Nothing. It would be suicide to contradict Sharia. It's an evolving process. You tweak on the margins. You introduce penalties for crimes that are not specified. You make it approximate to the closest that society will accept. And for that, you need competent manpower. You need qualified individuals. You need scholars who will go to school to learn these things. A school of theology, for example. School of theology is a relatively new thing. Now, if you look at Iran as a comparison, in Iran, there are religious institutions called the Hawza, 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 whereby you have these clerical establishments. The most prominent one is in Qum, where Khomeini was a teacher, along with other people. There is another very prominent one in Iraq, near Baghdad, and there are several others. In Sunni Islam, the most prominent school of theology in the past was Al-Azhar University in Cairo. Egypt was the hotbed of the learning. There were other schools, of course, in Iraq, in Syria, and elsewhere, but there were no such school of theology in Saudi Arabia or anywhere else in the Gulf for that matter. Guess what? Now there are. Now there are universities that actually prepare the manpower, religious manpower. It empowers scholars to learn theology, to learn the different schools of thought, to learn what Abdul Wahab, again, more about this tomorrow, because I will talk about Abdul Wahab tomorrow when I talk about the religious establishment. Now you have actual courses that are being given in order to train clerics, in order to empower them. And that process, it's like going to university. It takes 4 years, 5 years, you get degree. If you are good, you want to pursue, you do a master's, then you do a PhD. So you spend a decade learning and the manpower becomes a lot more professional. I suspect that in another generation, 20, 30 years from now, you're gonna have an alternative to Al-Azhar in Saudi Arabia. You're gonna have, I mean, there is now in Saudi Arabia several prominent institutions of higher learning, both in Riyadh and in Medina, especially in Medina, where students from all over the world go and study there. It used to be under the influence of the Muslim Brotherhood, but they've cleaned that up. And now you have a new generation of scholars that are learning theology. They are learning in Islam. When you learn theology, you start with kalam, word. Learning is very important in Islam. The Prophet Muhammad, in the Quran, the first injunction that he does to people, he says, Iqra, read. That's the first thing that he does. First thing that he does, he tells his believers, read. So therefore, learning is a process that now is being developed in a very systematic academic way. Now, again, we're still at the beginning. It's only been one generation where these things have happened. And in the past, the monopoly was with Al-Azhar. All the sheikhs used to go to Cairo to get degrees from Al-Azhar University. Now you have alternatives in Saudi Arabia. And I will tell you a story. This is outside of my realm, but it reminded me. There is a Syrian scholar by the name of Muhammad Shahrur, Shahrur, S-H-A-H-R-U-R. R-O-U-R, Shahrur. He passed away recently. Shahrur is a very, very, very interesting man to read. Very interesting man to read. Theologian. What he writes is heavy stuff. It's not for ordinary people. You really have to be into the field to really get what he does. He's very critical of Islam. Very critical. He says, we've wasted a long time. We have made lots of mistakes over the years. We've indoctrinated millions of people in a silly way. We have to respect them. And more importantly, we have to apply the sunnah of the Prophet. But not the way we've done it. And he has written several books, some of which have been translated into English. King Salman of Saudi Arabia actually called Shahrur in a few years ago before the guy passed away. He wanted him to come and teach at one of the schools of theology. And the guy actually went to Saudi Arabia and started giving courses, teaching clerics and future clerics about some of his own views. What are we doing wrong? What did we go wrong? Is rote learning what the Prophet taught us, what God wants us to do? No. God gave us brain. Each one of us has a brain. I got news for you, by the way. Your brain is not for decoration purposes. Use it. God gave you a brain. Use it. God does not want you to be a slave. And Shahrur trained a whole bunch of clerics. Now, of course, this is very controversial. What I'm telling you now, the ulama, the traditional people, the traditional clergymen that had power were opposed to him. They criticized him. They didn't want him in. But the king brought him in, nevertheless. He said, no, you guys have to listen to this guy. Listen to what this guy has to say. Think about some of the issues that he is raising. Let's use our brain to figure out what's going on and what kind of good believers we have to be. Believers. And he went back to the old books. Remember when Islam spread? Another story. Again, this is outside of my realm. But you are raising all these thoughts in me. You're helping me, actually. Thank you. I appreciate it. But during the first 100 years of Islam, where there were hardly any mosques, when Muslims arrived in Jerusalem, for example, during the expansion, there were no mosques in Jerusalem. Where did they pray? They prayed in churches. Which answers your question about the people of the book. They went inside churches in Jerusalem and they turned, and remember the old Qibla used to be Jerusalem before it became Mecca. So they prayed in churches. So the guy, Shahrur, is explaining to students of theology, he's explaining all these different things, and he's saying, we have to learn. We have to make sure that we don't become machines, automatically react for political purposes. The Prophet taught us how to think about these issues. We have to apply Sharia, true, but we also have to use our brain. Ijtihad in Arabic. We have to think, what can we add? What is our value? There are rules, we follow the rules. But we also have to be good mujtahids. We have to use ijtihad. I went off the tangent there, I apologize. I went off, but I cannot help it sometimes. I do that. Privilege of old men.
Thank you, sir. May I request the course coordinator, Professor Samina Hamid, please.